Welcome, everyone. Today we are talking about the new documents that we use as FDRP. Before we go any further, though, I would like to acknowledge the traditional owners of Australia and pay my respects to elders past. I come to you today from the lands of the Gunai Kurnai people in Victoria. I'm Joanne Law. I'm Director of Mediation Institute and also an FDR practitioner. What I thought we could talk about today are the Section 60I, Section 65H for anyone who's in WA, briefly about the Series of Dispute Resolution, and a little bit about our intake forms and other documents that we need to do. As always, I'm very happy for discussion as we go through. So please feel free to put your hand up or use the chat or whatever to get my attention. And you could also use the chat to introduce yourselves and let everyone know who you are and where you are. The first thing to talk about is the new Section 60I certificates that we are using from the 1st of April 2025. So you must use those certificates. Doesn't matter whether the parties started working with you before that or not. Hopefully by now everyone's read the updated information pages on the Attorney General's Department website. And you'll see over here, Section 66H, that's for WA if the parents of the child were never married. If you're doing a case with parents or grandparents, if the parents weren't married over there, then that's the certificate. And they're both available on the AG's site from the same location. And of course, either of these certificates is before parties make an application to the court for a parenting order or changes to an existing order, except one of the exceptions apply. The big change is that we now only give the certificate to the person who asks for it, which is a little bit of a departure from past practice, and there's some changes to some of the clauses that we need to make sure that we're aware of, and also updating our documentation. If you had a previous document explaining why certificate A was read weirdly, it still reads weirdly, but in a different way. This may be difficult to see depending on your browser, but I just wanted to show you the two certificates. There's very little difference between them other than the Section 60I, they accidentally left the between on up there. That'll be taken off, but it's not meant to actually have between there. And it references Section 50 of the Family Law, Family Dispute Resolution Practitioners. And yeah, the WA certificate refers to the family court regulations in and Part 5 is just the children part of the WA Family Court Act, which references the Family Law Act. So it's a little bit circular in nature. Any questions or thoughts about that? No. Section 50, it actually just directs you to subsection 22 about the matters that need to be determined. It's again a little bit interesting in the way it does it, but basically subsection 22 of the FDR regs. So they're not called regulation 25 or whatever anymore. They're now called subsections and subsections. So make sure if you're updating your document, you're changing that language as well. And there is a difference, and I've highlighted, so where it's identical between the Family Court Act of WA and the FDR regs, it's in bold, and where there's some slight difference, the words are not in bold. It's little slightly different, our obligations, but under the regs, we're not just determining if there's been family violence, we're determining whether the ability of one or more of those parties to negotiate freely is affected by family violence, safety, quality of bargaining power, risk that a child may suffer abuse, emotional, psychological, physical health of the parties. This new clause that's come in with the amendments, the undue bias or influence of a person, whether or not the person is a party to the dispute on the parties, and any other matters that the practitioner considers, has a material impact on the ability of the parties to negotiate freely. I don't know if anyone here's considered when deciding whether or not FDR is appropriate any undue bias or influence of a person. I haven't as yet, but it's an interesting concept. Any thoughts or comments about that new subsection 22F? That's not included in WA matters for people who were never married. But if they were married, then it's a Section 60I certificate. That's just to, I suppose, show that there are some differences, but not necessarily major differences. So let's have a look at a little bit more detail, particularly those top parts of our certificate that have changed. First one, instead of the parties to the dispute, we have the name of the person to whom the certificate is given. And then in relation to the matters in dispute that may be dealt with by a Part 7 order, which is a children's order. So when we're doing those descriptions, we need to make it clear who the parties are and what the issues are in the context of each case. So if it's a nuclear family, mum, dad, a child, children, you may be fine just to put the name of the person you're giving the certificate to and not put other names there. But if it's a situation where there's multiple children to different parents, it may not be clear who that is. So in the matters in dispute, then you may be putting the name of the other party and the children. So that's something to think about when you're doing these.
Sorry, Joanne, just what?
Yep.
So when we put the matters in dispute, we have to put the names of the children and the other party.
We don't have to, but you might have to. So
What is that?
If there's 3 children and there's two different mothers and one father, it's not going to be clear who the dispute's between.
Sure.
If you don't do
So
that.
if it's just a nuclear family, it's
there's no need to.
no.
But if you're thinking, and sometimes someone can have a dispute with about all of the children at the same time. Let's say they're wanting to relocate and they've come to
Sure.
do mediation with one of the parents of one of the children, but not the other. If you don't put the names,
Sure, that makes sense. And just, this is probably a silly question, but just to clarify, if the other party asks, we just do it in reverse, right? We can still give them a certificate. You know what I mean? Like it's not
no, that's right. But we just have to do another certificate. And if it was a certificate A, it'd be a bit weird that they're asking for a certificate saying
they didn't come.
Exactly.
Sure.
So we'd probably use that as an opportunity. Why don't we have another go at getting this mediation to happen?
Thank you.
Because it actually doesn't really work for certificate A if we look at the way it reads, the name of the person who the certificate's given, and it's due to the refusal or failure of the other party or parties in the proceeding to attend, that person did not attend family dispute resolution. So I suppose we could put the name of that person and then the others, but it would make it quite complicated. It works in the other contexts, but usually wouldn't have that scenario. So just some tips around that. We want to use really clear, neutral language. Be careful of bias when you're writing it. Match the client's intent. So I've had a number of conversations with the Attorney General's Department, and I know that it's been practiced in some services just to put parenting, but you're actually not doing your job if you put parenting, because Section 60I certificates are only for parenting. So you're basically, in effect, refusing to provide any information to the court, which isn't really appropriate, even though it might be just parenting decisions or parenting arrangements. We're not going to need to go to a lot more detail. We need to respect confidentiality and admissibility. So we're not going to put things on there that haven't been discussed with the other party. Let's say someone approached us, they wanted to try and do mediation about relocation, but we can't get party B to engage in at all. We're not going to necessarily put relocation on there because it hasn't been communicated to the other party.
So what would you put? You can't put parenting.
Yeah, we'd have to put parenting arrangements, living arrangements, something like that.
Okay.
Yeah, whereas if they have had mediation about relocation, then that's fine. It's not something that's not known to both parties. And of course, we won't go beyond the scope of the certificate, so we're not going to put things about property or something else that's not relevant there. But we need to be concise as well. We're not going to decide to put any sort of commentary or they were really difficult to work with. Or no, we're never going to put anything like that. Keep it clean. So, concise but informative. So living arrangements for the children's school dispute or a school enrolment dispute, relocation, something like that might be appropriate, because the We know that the certificates remain valid for 12 months. It may be that other issues come up that they haven't attempted to negotiate, and it might be useful for them to come back to mediation. Basically, that point I made at the beginning, identify the parties and or children by name if necessary for clarity. So basically, if because of the family composition, it will be unclear, or let's say it's a grandparent that's come to try and negotiate, it's going to be important to put enough information in the matters in dispute for it to be clear that it's between the grandparent and son-in-law, daughter-in-law, or whatever regarding which of their children. Does that make sense? Any other questions or comments? So here's some inappropriate. So those of you that can get to your chat, what do you think? Yeah, I think none of these are good. What do you think for mother won't let father see the kids? Maybe a little bit of bias in there. So what would you think might be more appropriate? Can you use the chat, or you're on the phone and you want to share?
Shared care of the children.
Yeah. Yeah, that'd be a great one. Or spending time arrangements or whatever. What about the next one? Dad wants custody. We wouldn't use custody anyway because we're not in the US. We're in Australia, and we talk about living with or spending time. Anyone got any thoughts? How would you say dad's wanting to change the living with arrangements? Yeah. Yeah, could. Yep, thanks, Naomi. Yeah, could be the same. Yeah, spending time arrangements or whatever. Parents can't agree on anything. That's a bit of a commentary rather than what the issues are in dispute. And again, mother refuses to co-parent. Doesn't actually sound that good either. So I'll just...
With the fourth one, with the mother refuses to co-parent, I was thinking, obviously, if they've been to mediation, there are some specific topics. So you'd be listing those things. Like that might be true that the mother is obstructive, or he might feel like that, but that's not the topics that they want to talk about.
Yeah, exactly. Yeah. And so it might be, communication method and shared parenting responsibilities for that one. But yeah, it could be, again, we're not being very descriptive, but we're also not just saying parenting. So yeah, and general parenting arrangements, I'm not sure I agree on anything. Yeah, so that was just a little list to think about how we might use some of those really common things. I wouldn't generally think you'd say father wants, spending time arrangements or whatever. I guess the same way we'd mutualise an agenda, but we're not putting down the agenda. But we might get a couple of the key points from that, perhaps. It's not too over the top. Makes sense. Here's an example for you. I'll talk it through for those on the phone because it's probably a little bit hard for you. So David's a carpenter. He lives in Perth. He's got a 12-year-old son, Eli, with Olivia, who's 35. She's a school teacher. She's returned back to Newcastle in New South Wales. They were never married and they separated a couple of years ago. They've had informal co-parenting arrangements. We're working fairly well. Olivia was flying back to Perth with Eli for visits during school holidays. David was contributing to the cost, and she had some friends and family she'd stay with. But over the last 18 months, those have declined. She's got a new partner and recently had a new baby. She's told David that it's just too stressful now to do the interstate travel and then wait till Eli's a bit older. He's contacted an FDRP trying to get a parenting plan with arrangements in place, and were able to contact Olivia and had a pre-mediation set up. You did do a pre-mediation, but she cancelled the mediation, then ghosted you. So David's now come and asked for a certificate. So again, you can use the chat if you can. What type of certificate will we issue?
The 66H.
Yep, absolutely, because the parents weren't married. And who would we give it to? Yep. We'll give it to David, because the one that's asked for it, and Olivia's disappeared. And what would you put on the matters in dispute line? What are some...
Shared care of the child?
Yeah. Would you name the child?
Yes, because she's got Joy now as well.
Yeah,
so, yeah.
Exactly, yeah. So there's no confusion that, I don't think he's looking for shared care of...
You know.
Yeah. although she does sound lovely. So, yeah, absolutely. So that's a scenario where, just to be clear, you might put the name of the child on that one. You could put Olivia's name potentially, or it might be just sufficient to just have Eli's name on there, because if it does go to court, it's going to be quite clear that there's just the two parents.
Can I ask a question about the 66H certificates?
Yeah.
Just because I'm not really familiar with them. I don't work with clients really, but do you put reasons the same as 60I, like the A, B, C, and D and E, or they don't have reasons?
Yep, they've got the same set of reasons, and they've updated it. Yep. So in this case, yep, it's still an A. On whose name are we going to put on clause A? Is it David or Olivia?
David.
Yep. That's right. So yeah, before we would have put Olivia's name under the old certificate, which always used to cause clients a lot of confusion. Yeah.
Sorry, I have another question.
Yeah.
Just curious, in this context, would most people be issuing an A? It seems like she did an assessment with the FDRP, but then wouldn't come for mediation.
Oh, yeah.
Would we do an A given that she's not attending a mediation, or would we call that inappropriate because she's not coping?
Yeah.
I'm just curious to gauge what people would do.
Yeah, we can have a little bit of a poll. What do people think? Would you do it as let's go back.
I'd do it as an A.
Yeah, so an A because she's dropped out. We've assessed it as appropriate. Or we could decide that, yeah, she's not coping, that it could be a B. Could be, now that pre-mediation is regarded as mediation, it could be a C. Attended dispute resolution. Oh, they didn't attend it with you and the other party though, did they? So
Yeah, so that wouldn't work. So
no, C doesn't work. Yeah.
Yeah. So I was just curious because I had an employer in the past who would always issue B if people had been to their assessment, no matter what. If you've been to assessment and then something goes wrong, it's a B. But I know not everybody does that. So that's why I was just curious to see.
No,
obviously, other people would do A.
Yeah, absolutely. No, it's great that you asked that because, yeah, A or B, and it is up to the judgment of the practitioner. I'm not that comfortable with always do one or the other. I think we do need to take the circumstances into account, but yeah, and the scenario doesn't give you enough information to know whether she was extremely stressed and marginal, and you think, oh, look, it's reasonable, it's not appropriate. So yeah, no, that's good. Thank you for raising that. Any other thoughts or comments? So this is from the fact sheets. I'm actually a little bit disappointed with the way that the fact sheet's worded because it doesn't actually identify that we have to determine whether people will be able to, their ability to self-determine is going to be affected by the issues. It just talks about whether there has been family violence, a history of family violence. But anyway, so yeah, that clause B is where we're deciding that it's not appropriate for family dispute resolution. I don't know. I should have had a little poll and we could have seen how many of those here thinks it's an A and how many would do a B. The genuine efforts pretty much say the same, although in the guidance it makes it clear that a practitioner should not, and I've put that underlining in, issue a certificate where the parties come to an agreement in relation to all the issues in dispute, as you do not need one. I know sometimes services have had a practice of just issuing the certificate regardless and putting it on file. It's not what's recommended. Basically, if the agreement breaks down and they either don't have a clause about going back to mediation or they decide that they don't want to, then you're able to issue the certificate. That was back whenever it happened. Any thoughts or comments like that? Is that routine practice just to issue the certificate regardless?
If it fails down the track?
No, if it succeeds.
No, I've never done that. I wouldn't know. No,
good response. I've heard around the traps that there's a bit of a practice of doing that at times, but definitely not encouraged.
That seems odd. I have had clients come back. Only not many. But, but definitely have an issue case. No, not for me anyway.
No, it's not. It's definitely not recommended practice. Yeah. So just a note on keeping files. Oh, under the new regs, section 26 has now got requirements in relation to records and information. So we've got to ensure that all records relating to family dispute resolution conducted, including case notes and files, stored securely and retained for at least 24 months. The practitioner must not use information acquired while conducting family dispute resolution for personal gain or the detriment, of course, and the confidentiality provisions apply. Now, could be a little bit interesting for practitioners who are working with a service and then leave. That's only just occurred to me what your obligations are regarding this information, because it's normally going to be stored on the work server.
Presumably they just contact if it's Catholic care or whatever. Right?
Yeah.
I shouldn't imagine you'd take it with you.
No, I wouldn't imagine either. However, these are obligations for us as practitioners. No, I'm not advocating that practitioners try and tell Centre Care or RA.
That would be
all my files.
I'm sure then you could access it if you needed to. If something came up, they'd allow access.
Yeah, and it's generally for the purposes if there's a complaint that arises.
Yeah, exactly.
Or a Section 60I certificate needed. But it's interesting because these are personal obligations.
This would probably apply more if you're working with a private agency or something like that. The obligation appears to be that an accredited family dispute resolution practitioner must ensure that any records relating to FDR conducted by them, including case notes and files, are stored securely to prevent unauthorised access and retained for at least 24 months. So you don't necessarily have to retain them yourself, but you should be taking practical steps to ensure that it does happen. Yeah, so just something to be mindful of if you are working with a group and you're not actually retaining the files yourself.
But even as if there was a Section 60I certificate required, they wouldn't be coming back to you if you're no longer there. They're going to be going back to the FDR, the Family Relationship Centre or whatever. They're not going to contact you directly because they wouldn't have that access.
Yeah.
Because you would have all your emails, all your contact is through, say, for example, if you're Catholic care, so your email's Catholic care. If you're not there anymore, you don't exist.
Yeah.
So they'd have to go back to Catholic care and then they'd have to find a way that way to issue or whatever.
Yeah, there are provisions on that. I'll have to.
Yeah, I think I did read somewhere where they said that the organisation need to try and get in contact with the mediator, the FDRP, and if they can't, someone else can issue the certificate.
Yeah,
There
are specific provisions in the regulations. I know if the practitioner dies, but I'll have to refresh myself on I haven't got it memorised yet, sadly. It's sad that I knew all the previous clauses.
Okay, I did look that up. It is Section 24 that speaks to the requirement of giving certificates under subsection 60I of the Act. So the practitioner may give the certificate to the person on behalf of another FDRP only if the practitioner is familiar with the case and the other practitioners become incapable of giving the certificate. So the note says incapable may be if they're unable to be contacted or they have died. So being familiar to the case may mean a handoff when someone leaves an organisation, but it also means keeping good file notes that someone can use to familiarise themselves with.
What documents do we produce and keep? Agreement to mediate or other document. So we strongly recommend that you're using a document that gives the clients the mandatory information that you've got to provide under, it's not Reg Section 21 and the Family Law Act. I've got a listing of what all those clauses are in a minute. So sometimes I've been coming across a few problems with complaints where private practitioners are relying on a website or other information and haven't used an agreement to mediate. I'd strongly encourage everyone to formally have a document that includes all of your obligations and the information you've got to provide that you give to the clients. You get them to sign to acknowledge that they've received it. If you're working with clients where English may be a challenge or whatever, think about how you're going to make sure that they do understand the information that you've got to provide and can acknowledge that. Your intakes and screening documents, again, strongly encourage you to use a form or a screening tool to manage the information. Complete the process appropriately. For FDRPs, it generally isn't appropriate for us just to scribble some notes on a writing pad. for our intake process. Again, it still can be done by somebody else, but you've got the challenges around confidentiality. If you are in a service, you really need to make sure that your intake officers are getting a confidentiality agreement signed early on in the process to try and prevent your documents being subpoenaed. If it's not a registered practitioner who's doing that work, they are not just collecting the basic information, but doing intake and screening, collecting confidential information. Your records regarding your invitations to FDR, particularly if you're issuing a Clause A. So generally, if there's a complaint, there isn't really a mechanism for the complaint body to say, oh, I think you should have issued that certificate, not this one. Like, you've got the professional judgment. But if you've got no evidence to say that you've actually tried to contact party B, then that could be a problem. Have you actually followed the required procedures? Have you given them the information that you need to provide? That's a good question. Is any FDRP doing intake covered by the confidentiality provisions, or does it have to be the FDRP who would be chairing the conference? I believe it's any registered FDRP, even if you're sharing part of the process with another practitioner. So the clarification is that it is part of the mediation if it's being done by a registered practitioner. And you'd want to keep your certificates and any agreement reached and case files made. Now, I believe, and this is conversations I've had, that you don't have to keep your scribbles that you've made during your mediation, but you have to dispose of them appropriately.
Do you think there seems to be a real range of opinions on that point?
Yeah. I know if you look at my scribbles, I can't read them.
Oh, no one would want mine. I couldn't even read mine in today's mediation from one room to the other. I was like, hang on, sorry, I just can't even read my notes right now. Taking the very conservative, risk-averse view of working out ways we could actually hold on to our notes. But I think that's completely, then we come across confidentiality issues because we're scribbling both of the party.
Yeah.
So it just doesn't sit well with me. I heard one way of doing it the other day, which I like. It hasn't been tested, obviously, but which is basically just in our case file situation, just right, okay, these are the agenda items, and put a basic case summary of what was agreed to in the mediation, and just do that as our case notes.
Yeah.
And then have that covering that provision rather than just our scribbles. I like that. So it's a bit more than what we're doing now, but it's not the extreme of then keeping the note.
Yeah, exactly. And we don't want to be doing things like taking photos of our notes, because then that's not necessarily going to put them in a secure location as well.
Okay,
So,
exactly. There's so many issues with that, a story, and there's so much. And then my manager said to me, we might just have to scan them into our database system. The extra work, because like today, there would have been 20 pages of notes. Yeah, but anyway, like I said, the way that I was told, a good way to do it, still the quite regarded person in our industry who said it hasn't been tested, so they don't even know if it's right.
yeah.
It's just that's what they're thinking they might do in their practice.
Yeah. And look, with the conversations I've had with the Attorney General's Department, they are intending like case notes rather than necessarily scribbles.
Okay.
So again, that's something
That's good.
to see if we can get that a little bit more clearly.
Yeah.
But we should be keeping case notes. And the reason they brought this in, I think, was that there was this kind of myth or practice of people just destroying everything after the mediation, and that's really not appropriate. So I think you should be taking a few minutes and just creating a case note of what the agenda was, what the key issues were, if that's
makes more sense.
Yeah.
The common sense argument of this, that makes more sense.
Yeah, that appears to be what was intended.
Great. That's interesting.
See if we can get some more clarity on that.
Perfect.
Yeah. So it's basically all of the official documents you use, keeping that evidence that you have followed your obligations. That is really important. And particularly if you are a private practitioner and you've had to create all of your own systems and processes, really make sure that you are doing those things and keeping a record. So generally a locked computer would be secure enough, ideally with some antivirus software. If you're keeping paper copies of having a filing cabinet, don't just leave your files out everywhere, even if your office is in your home. I was doing a complaint once and the person saying, oh, where are they? Oh, the kids have been in here. They've been drawing on things. No, your kids shouldn't have any access to your client files. So yeah, just regardless of our location, we should be using appropriate processes. I was going to very quickly go on to the certificate of dispute resolution, but any further thoughts or questions about the files and this new update we've got? That's all good. So I haven't got the copy of the certificate of dispute resolution. It's fairly straightforward. Came in the 2021 merger of the courts. Sadly, it endorses dispute resolution by people other than FDRPs and registrars who are deemed to be FDRPs under the regulations. But the information that you need to be clear on what's happening is in the central practice direction. I had an inquiry come through the other day from someone saying, I need an FDRP to do a genuine effort certificate. No, we don't do the genuine effort certificates. Those are done by the lawyer or the party if they're initiating a court action and generally used for property matters. That there isn't an equivalent to a Section 60I or 66H for property. However, you could have it as a policy for your property that you issue a letter saying that certain person approached on these dates and it was attempted or the other party refused. So you can provide very basic information. Oh, excellent. Thank you so much, Beck. Rebecca's dropped the certificate of dispute resolution in the chat. So if anyone wants to open that and if you do have any questions about it. Has anyone had these? So sometimes people will come back to the FDR that they attempted mediation before the court. So generally gets named on the order to go to family dispute resolution or dispute resolution. It gets named what service or individual. So often it'll be the lawyers will have people that they use, but it can also be the mediators. So has anyone worked with these, had these, got questions about them?
What's the purpose of them?
They're to give the court information back when they order people to mediation. After the court will send people to dispute resolution, usually. So they might send it to a registrar, but if people can afford it or they don't consider that there's contraindications, they'll send it to private mediation or legal aid or a private practitioner. And then the confidentiality applies. What the court gets back is the certificate that says whether people attended, whether they made a genuine effort. There's an obligation that at the time the lawyers tell people about costs and future costs. They don't actually have to provide it to the mediator, but the mediator is supposed to check whether or not people say that information was shared. So yeah, it's an interesting little process. Have a look at that certificate if you haven't come across them. It is now part of our system for a few years now. This little section, and because I'm just mindful of time, is the information we've got to provide both in the regs and also in the Family Law Act. We now have to make a statement that we're an accredited family dispute resolution practitioner. So it's Section 21 that's got the information we've got to provide in the regs. If you haven't done that, you should update that in your documentation. If you're in a service or a multi FDR function, services probably wouldn't, but in a multi FDR private practice, you might have a mediator's CV or something like that that you provide to the clients, or just make a statement about what services. So it's very important that non-FDRs don't give the impression or that a party would think that they are an FDRP because of the way the information's provided. If someone's making themselves out to be an accredited family dispute resolution practitioner and they're not, there can be quite severe consequences, including that they may have registration refused. So there was a situation a while back where that did happen and the person was refused. They'd done the training, hadn't registered, were putting themselves out to be an FDRP and had some complaints before they were even registered, and eventually the Attorney General's Department refused to register them. So they take this very seriously. So make sure your intake officers are clearly not easily mistaken to be accredited. We need to tell people that we can't provide legal advice, although there are other provisions that registered legal practitioners can provide advice and procedural advice can be provided. However, most lawyers don't attempt to provide legal advice, because then you've got a whole can of worms under your legal registration of providing advice to people that have got a conflict. So my recommendation, don't provide legal advice. Refer people off to someone who can properly, independently advise them, because they're not going to get the same level of advice if you're trying to be an FDRP and lawyer at the same time. And if you're not a lawyer, don't be a bush lawyer. Refer people off. We have to tell them about our confidentiality and disclosure obligations. We can't just say, oh, everything's confidential. We need to tell them about when we wouldn't hold something confidential, such as if there was concerns about child abuse or if we thought that some personal property was at risk. So that needs to be disclosed in some way. And the same thing, the inadmissibility, so that it's generally inadmissible, except if we're the only evidence of child abuse or neglect. We need to let people know we're a mandatory reporter. And it also does still say that we need to make sure it's very clear what our fees are, including hourly rates up front before. And our complaint mechanism. Don't allow your complaints to turn into a grievance as well. Make sure that it's very clear and easy for people to know how to make a complaint if they're not satisfied with something and don't feel that you've addressed it properly. It makes things a lot worse if they have to go to the Attorney General's department to find out who your complaint handling body is. It doesn't make sense to do that. And sorry, I'm missing the chat. And then again, in the Family Law Act, we've got these other prescribed information that we need to provide the client. Policy about reconciliation is going in the next Act amendment. And we've also got to make sure that we're giving people information about the best interest of the child, the extra provisions for Aboriginal and Torres Strait Islander children, if that's the case for your clients, and also the information about parenting plans and what they might consider, including that they might consider having provisions in place for what happens if they can't reach agreement. So hopefully everyone's got all of that information, and then the costs and being able to be ordered back to, I think so. I haven't put the long text because it's pretty easy to look up and double check. So Section 117 is changing the cost. They're restructuring the Family Law Act a little bit with the 2024 amendments, which come in on the 10th of June. So there's another update to your documents that you'll need to do there, because you'll have to reference a different section. Any questions or thoughts about all of that information that we need to provide to clients? Is everyone doing that? Private practitioners, are you remembering that you have to do all of these things? Don't tell me if you're not, just go and do it. And so that's all I've got for today.
Joanne?
Yep.
Could I just ask, hi everyone, my name's Rebecca. I'm actually very new to this role, so I'm learning a lot as we go.
Yeah.
I just wanted to double check with the issuing of this certificate 60I, and it goes to obviously to the person that requests it.
Yeah.
But what happens if the other party also requests it?
We issue 2 certificates.
You do. Yeah.
Yeah.
So if, for example, even if, it hadn't actually gone ahead, so you'd had 2 intakes and then for whatever reason it didn't go ahead, you would just issue to both parties if they both requested it.
You would, yeah.
Yeah. Okay.
Yeah. Yeah.
Thank you.
So that's what they want now.
Yeah.
It's-
Awesome.
Do we know the main, sorry, I'm on mat leave at the moment, so it's gone over my head a bit, but do we know the main reason for that change?
Well, I don't know. It didn't really make it clear in the explanatory statement of why they made that choice. It may have been like a interpretation of the legislation that they thought that would be more appropriate, but they didn't share the driver for it. Mystery.
Okay.
I'd love to hear if you find out.
No worries.
Yeah, because I think most of us think it's fair to let both people know that a certificate's been issued, but yeah, it's not necessarily how it is. So this is just letting you know. So mimembers.au do events. So if you're a member, just go there, log in first, and then you'll be able to attend that for free. I attended a really good PD this morning. So what we're trying to do is, if we become aware of other PDs that might be appropriate, we're putting them up as external events. So you'll find that you just need to click on a link and it'll take you. Hayley is running a family law pathways one on the 12th of May. So you click those and you'll go through to the organisation. If you are aware of good quality events that are running that you're seeing isn't up on the events list, let us know, because we're always happy to make sure people know what's on. We do group supervision once a month. That's on next week. We're trying a Friday afternoon, BYO Friday afternoon drinks, but it's an opportunity to debrief. They're never recorded, so you do have to attend live. There's also live networking happening in Adelaide in collaboration with the Law Society there. So if you are running or interested in hosting a live networking event, just get in touch, because we're very happy to support that as well. And they really usually just do them at a cafe or a pub or somewhere, and just go and hang out with some other mediators, where so many of us work alone these days. So it's always a good opportunity. Excellent. So we're at time. Any final thoughts or questions? Hopefully that was helpful. And I've got another one going into record keeping and case management a little bit more in the practice management topic.
And this will be available in recorded webinars on the MI members website too.
Yeah. So
in the next few days.
Yeah, I might put because of the links and all of that, I might put it up, the PowerPoint up as well in the document, so you can download a PDF of that. Excellent. Okay, any final comments or thoughts? If not, I'll see you next time.
Thanks, Joanne.
Sure. See you.
Take care.
Thank
Bye.
you.
Thank you.
Bye.